This will be the People News. All right, this video is without prejudice and or without recourse. Not attorney, not giving legal advice because I'm not attorney. That's why. Look straightforward. Never look straightforward. Always look around you. Be able to protect yourself by any means necessary. That means if you want to learn something outside the box, then do so. All right. This is part 2 of the missing juries.
Even got it on the Facebook chat, so we're good there. Now, it seems like, I think to a lot of us, that so many things in the legal system don't make sense, and from your book, it seems like a lot of those don't make sense because they're essentially flipped 180 degrees from where they began. And I'd like to hear your thoughts on some of those, starting with the trials by jury and plea bargains. Now, a few years back, I was listening to oral arguments for the case of J. Lee versus United States, which had reached the Supreme Court. Mr. Lee took a plea bargain after being incorrectly informed by his attorney that he would avoid deportation from the country where he had lived his entire adult life if he took this plea bargain. It turned out to be wrong. His attorney said, "It's totally my fault. I was wrong." So it went he tried to appeal to get a jury trial instead. And the government was arguing this man didn't have a right to a jury trial. And during the oral arguments, twice at least, Justice Sonia Sotomayor noted that trial by jury is guaranteed in the Constitution, whereas plea bargaining isn't. So how exactly should we understand this situation where the government is standing in front of the Supreme Court arguing that constitutionally guaranteed rights must be subordinated to their preferred non-constitutional methods of dealing with things?
Yeah, so this is has been a process over time. So our jury in the United States was based on the English jury. And so that jury was such that we did have grand juries decide whether criminal defendants should be tried. Then we had juries decide whether people are convicted of crimes. And virtually everyone took the jury trial, and almost no one pled guilty. So then we established that system in the United States. We very much established it based on this history in England. And then what happens is around the end of the Civil War, we have some increase in crime, and we have...
I'm going to pause that. Towards the end of at the end of the Civil War, it's actually when bar members started popping up, y'all. Just saying, is coincidence or not? But after the Civil War, that's when they all started popping up in state by state by state. By the way, New Mexico was the last one to accept bar members.
Some establishment of this idea of plea bargaining, and that is to incentivize someone to plead guilty by getting some benefit. So at that point in time, we did have an increase, or we had sort of this establishment of this idea of plea bargaining. Again, then we get to all the way to essentially World War II. By then, we're up to probably over 80% plea bargaining, this kind of acceptance of the system. But even at that point in time, there wasn't a significant penalty. I'm sure criminal defendants thought it was a significant penalty, but not where we are today. And so some people felt like they could go to a jury trial. But then you get into the 70s and 80s, again, this idea of an increase in crime rates, and then some incentives by legislatures to actually enact laws that drive plea bargaining to increase. And so we have, for example, in New York, we have the Rockefeller laws that put in place mandatory minimums for certain drug crimes. And what that allows a prosecutor to do is to say, if you do not plead guilty to this crime, I'm going to charge you with this crime that comes with a mandatory minimum. And this also is established in the federal system. And then on top of that, we have federal sentencing guidelines. And those federal sentencing guidelines allow, and then also in the states, allow a prosecutor to say you are going to get a benefit for not taking the jury trial or pleading guilty, or in other words, be to your detriment if you actually take a jury trial. And so all of these things contribute then to prosecutors being able to use sentencing to incentivize, or what I would say coerce, someone into pleading guilty, even if
or even retaliation. So if you do not take a plea, then the courts is going to retaliate against you since you did not make it easy on them. Just saying.
someone is innocent. And I would say, even if someone isn't innocent, to me, that's the whole point. You have a right to a jury trial, and we're going to talk about why that's important, even if someone's is not innocent. But we get to the point then where we are today, which is very few cases tried by juries in criminal cases, and there are other patterns in the civil side on the civil side, but we have less than 1% of civil cases tried by juries as well.
Under the Constitution as it is currently written, do you think that plea bargaining is legal, or kind of what's its status, and should there be a future for plea bargaining, or should it be done away with? Is there something else we can do? Any thoughts in that direction?
Yeah, absolutely. Plea bargaining is absolutely unconstitutional. I'm going to be one of the only people that says that, but it's absolutely true. Again, the jury in the United States was based on the English jury, and so the right to a jury trial did not involve that prosecutors could penalize you with more time in prison for actually taking the jury trial. And so this is just a total turning on its head a right that exists in the Constitution. I want to just briefly say, so that we can give this some context, the United States Supreme Court said yes to plea bargaining in a few different cases, but one of them is the Bordenkercher case. And if any of you are interested, you can take a look at this case from the 70s. And this is a case where the criminal defendant was charged with forging a check for about $90. And the prosecutor said to him, plead guilty and you'll get 5 years in prison. But if you don't plead guilty, you're going to get life in prison. And so this criminal defendant said, no, I'm not going to plead guilty and get 5 years in prison for a forged check of $90. I'm going to take my jury trial. He takes his jury trial. He gets sentenced to life in prison when he's convicted. And he takes that case all the way to the United States Supreme Court. And the United States Supreme Court, in a 5-4 decision, says plea bargaining is this important part of our criminal justice system, essentially an efficiency argument. And one of the things that I want to sort of emphasize is that there's nothing about efficiency in the Constitution. And I would argue that our system of juries can be more efficient.
I'm going to back this up a little bit more. Now, there is this thing called remedy. So it's a $90 forgery check and spent 90 years in jail, prison. However, whoever he forged gave him $90 and then also interest of maybe saying $200 to that victim. That would be a remedy. And that would be a man-to-man contract. And the states cannot intervene in that. But because the state of Texas, in my case, is a victim, without being a victim, they kind of took over the punishment where you could not get remedy from the victim. Now, there's obviously certain remedies that does not fix the issue, but in that case, like a $90 check, you give the guy $200, or you can say, hey, look, I did wrong and all that. I'll stand an honorable man. What X amount of time do you want me to spend in jail? And the guy, well, 1 month. But we forgot actually how to negotiate and actually become men to men, right? Even in a good book, it says that you should create remedy with the ones that you committed harm upon, that you trespassed upon, before you even go to court. I mean, it sounds like they was wiser back then than they are now. That's 2,000 years ago, people. Sit and think about it. They was actually smarter than you are, or we are. All right.
if we have some reform, and that's a lot of that is because of lawyers and judges and us not being as good as we can be. But regardless of that, there's absolutely nothing in the Constitution that says we need to be efficient. And this system, in other words, is made up, and we need to make change.
I really like your point about efficiency, because one thing that has struck me over the years is we're a very efficiency geared society in the United States, but sometimes it's inefficiency that is protective. Not always.
Really? So it takes 2 or 3 years to get remedy when you sue cops and all that. That's efficient? Nah. Especially when you become the victim. Yeah, it's not that efficient, people.
But it's something to consider that the purpose of the system isn't to like crank out convictions and other verdicts as quickly as possible. It's to uphold justice in theory. And so looking at it from an efficiency standpoint is going to bring people to different conclusions about how it should operate versus looking at it from a justice standpoint. So thank you very much for bringing that point up. Kind of along those lines, another thing that doesn't seem to make sense to a lot of people is the situation.
Alrighty. Let's see here. How long I've been recording? 11 minutes. We're going to go ahead and shut it off here, y'all. Diesel Weed People News. Bye.